by one of the joint account holders. Now there are three people. There is a bank or a financial institution, and there are two account holders holding it jointly. Now two of the people cannot get together and modify it without the consent of the third one. Means the bank and one of the holders cannot come together and pledged with the bank by one account holder without the consent of the other. Bank also cannot set off fixed deposit against any claim in respect of one of the account holders. This tripartite agreement cannot be bilaterally modified by one of the joint account holders, for example, by pledging the account with any third party. So joint account is joint account. Just because you write that either or survivor doesn't mean that anyone can do anything. It is the jointness continues despite that. This is a decision of 2005 Supreme Court. The Supreme Court case of 2005. Yeah. Now, coming to succession. Now, as you know, the law of succession in Goa, succession and marriage laws in Goa are different from those in the other parts of our country. Succession and marriage in Goa are drawn from the Portuguese Civil Code. In other parts of India, the succession and marriage is governed by the personal laws, that is Hindu law and Muslim law, mostly. In Goa, the law is common for everybody, but it is under a code. So now coming to succession, I'm telling you a few principles of succession. There are two types of succession. One is intestate succession when there is no will. And the other one is testamentary succession when there is a will. Intestate succession is called also statutory. It's succession by law because there is no will. So the law decides or determines what is going to whom without any intervention from anybody. It's all by operation of law. So it is called intestate, statutory, or succession by operation of law without testament or will. That's what it is. The other type of succession is testamentary succession where a person makes a will. What is a will? You know it. Is a document which shows how a person wants to dispose his estate or his effects, his wealth or his assets after his death. The very word says it. It is what you want to do, what your will is. The document itself is called will. So that document records that. Next. How is a will made in Goa? In Goa, you have to prepare a draft of the will that you want. Normally, this is done with the help of a lawyer. And you have to take the draft to the office of the civil register cum sub-register and notary ex officio. You know, and every taluka, there are 12 talukas in Goa, Navemarg, Vasco, etc. In each of them, there is a so-called sub-register who is also a civil register and is also a notary ex officio. Now, in that capacity of notary ex officio, he is empowered to draw up the wills. Theoretically, it is he who draws up, but actually you have to give him a draft of what you want. Once you give that, he does the rest. Will cannot be done with private notaries. There are a lot of notaries, and every alternate building there is a notary. You can't do a will with those notaries. This is a notary public. This is a notary public ex officio. It's a government appointed notary, which government functions. It's a government servant. It's a civil servant. So the civil register takes that draft after reading it, confirming it. He gets it checked and rechecked, and then he gives you an appointment. On that day, the notary's clerk, the civil register's clerk, he writes your will on a book, which is called Book of Wills. On the day of the appointment, he writes the will, and it is recorded in the Book of Wills. And once it's written there, it becomes an official document. What is it? Yeah. Now, once a will is made, only the testator, the person who makes the will is called testator. If it's a woman, it's called testatrix. Only the testator can take a copy. Nobody else can take a copy of the will. But after his death, other persons can take with a death certificate. Until his death, it remains in secrecy. It's available only to him. Now, sometimes the question arises whether a deceased person has made a will or not, especially maybe your own parents or someone with whom you're connected. Have they made a will? Because if there is a will, everything changes. How do you know it? The only way to know now is through RTI, Right to Information Act. You have to file an application, and the office will furnish you the information whether such and such person has made a will. They will conduct the search and they'll give you the information. Now, in other parts of India, in Bombay and other parts of India, and even in other common law countries or English law countries, like Singapore and that kind of place, the will is a private document. You can do it in your house or in your lawyer's office, and it's written on a piece of paper with two witnesses. After your death, that will is filed in the court for what is known as probate. The word probate means proof, and a certificate is issued by the court, which certificate is also called a probate, saying that this will is genuine, it's not forged. Now, this probate proceedings take a long time. It is a rather tedious process. Notice is served on all the heirs, disputes are raised, people say it's valid, not valid. This is the story, particularly in Bombay, where so many people are. This probate is a famous thing. So the will is subject to the probate. Only if it is probated through court, then the will becomes operative, means you can act on that will. Until then, the will remains there. Now, in Goa, this hassle is avoided because of the Portuguese legal procedure, which I just told you. Because your book, right from the beginning, it is already probated. It's written directly in the official book of wills. So there is no need of probating it. It is foolproof. For a will, you need 3 witnesses. For a will, you need 3 witnesses. Okay. Now, in the case of married persons, when a person is married in Goa without any antenuptial contract, most people don't make an antenuptial contract. It is presumed that he is married under what is called communion of assets. You must have heard this word. Now, communion of assets, it means that from the date of marriage, husband and wife have equal share in everything, 50% each, in all their assets, income, etc. This is what communion means. Equal shares to both. You may be very rich, other person may be very poor, but the shares are equal. Now, out of this 50%, each spouse can dispose only 25%, which is known as disposable quota or disposable share. The remaining 25% devolves after his or her death, children in equal shares. So if you do any will or gift or anything, it can go up to 25% of your 50% share. The remaining 25 goes for your children. The same with your spouse. He or she can dispose up to 25. The remaining 25 devolves on all the children. Now, if a will or gift is made to one son or daughter in excess of disposable quota, it can be scaled down in inventory proceedings after that. If there's an arithmetical calculation done in inventory proceedings after that, if your share of the beneficiary exceeds whatever he is entitled to, then there is a procedure to scale it down. Okay. The remaining 25, as I said, devolves on all children equally in terms of law, and it is called the legitime or legal share. Legitime means lawful share. It's a share which devolves by force of law. Whether you want it or you don't want it, it goes to your children in equal shares. Now, if a couple dies without leaving any will or gift, their estate devolves in equal shares on all children without distinction. Where both die, no will, then the entire thing goes to all the children in equal shares. Now, son-in-law and daughter-in-law are not heirs. They claim through their spouse who is an heir or heiress. This is very important because in many families, the initiative for this kind of things comes from the son-in-law or daughter-in-law. It must be kept in mind. It is the son or the daughter who can and should do the thing. The respective spouse, he just stands behind, and through his communion of assets, he gets a share in what his or her husband or wife is entitled in the estate of his or her parents. As I said, a will requires 3 witnesses. If a person does not know English, he will have to take an interpreter translator and have a copy of the will made in Konkani. Most people talk Konkani. So there are 2 columns. One is in English, one is in Konkani, and there are people who are private translators recognized to do the translation in Konkani. This is compulsory. To modify a will, you must make a second will. You must make a second will with the modification, and the later will prevails. Normally, a fully new will is made and that modified clause is introduced in it. Rather than sitting with 2 wills, a new will is made and whatever modification you wanted is introduced in the second will. When a couple married under communion of assets makes a will, both husband and wife have to make identical wills on the same day and time, along with a document called deed of consent. So the correct practice is both go together to the register's office with identical wills. They are mirror images, sort of. The register confirms, compares all that. And there is a deed of consent in which husband gives consent to wife and wife gives consent to the husband to make the will in that way. So 3 documents in all are done at the same time on the same day. So this is the way to make a will of a couple married under communion of assets. Now, a surviving spouse can't change the dispositions of the common will made along with the deceased spouse when the spouse was alive. It's very common in our midst. Both the parents make a will in a regular way, both of them identical wills with deed of consent. Then one person dies. Suppose the husband dies, or the father dies. Then the children pressurize the surviving spouse. Normally it's the mother. And by that time, she is quite aged. She may be in the 80s or 90s. And she's pressurized, especially the child or the son or daughter who is looking after her, pressurizes her to change the will. It is not permissible. That will which was made in common with the husband cannot be changed by the wife. Many people do it. Many people have done it and they have got away with it. It is not legal. It's not legally permissible. If the couple has made a will and one spouse dies, the other cannot cancel the will also, which is the same thing. You can neither modify nor cancel it. That will of the couple is sacrosanct. It remains that way. And it has to be executed in the manner in which it is. Now, a widow or a widower can make a will of assets acquired after the death of the husband or wife. After the husband has gone or after the wife has gone, if the widow or widower purchases something or acquires something, yes, he or she can make a will and dispose of it freely, because for the simple reason that marriage ends with death. So once one spouse dies, the marriage is over. After that, there is no communion of assets, nothing. You are free to dispose whatever you have in the way you want. So a widow or widower can make a will of the assets acquired after the death of the husband only. Assets of the communion or matrimonial estate cannot be disposed by the surviving spouse. Remember that. When one spouse dies, you have to have an inventory to partition the whole thing. Suddenly the surviving spouse cannot start dealing with the assets, not selling them. She or he, the surviving spouse, is only an administrator. He cannot dispose of the assets the way he or she wants. Now, a person to make a will, not say this, has to be in sound mind and in pre-consent. And sub-register is supposed to check this. They do ask questions, especially when they see very old persons or less literate persons. They ask questions, whom you want to give, what you want to give, etc. They interrogate. And they are supposed to interrogate, they are entitled and they are obliged also to do it, they are bound to do it. This is because often children take aged parents in their 80s and 90s under pressure, forcing them to make wills. The notary public has powers to ascertain the position and can refuse to make a will. He can simply say, I am not satisfied, this person is being pressurized, she or she is not in sound mind. He can refuse to make a will. So it's not something that you can do as of right. The notary has got a lot of power in this. And I have seen cases of notaries saying, no, I am not making this will. Now, inventory proceeding. This is a famous word. All Goans know about it. Many Goans are very fond of it. And half of Goans are bogged down in inventory proceedings of their properties. You have properties, inventory follows after that. Now, what is inventory really? You must be already know. After the death of a person, if there is a substantial estate, inventory proceedings is filed in the court. They are really speaking administrative proceedings under judicial supervision. It's a distribution of the estate, but the judge presides. So since the judge presides, is held in court, lawyers are involved, it looks more like it is a legal proceeding, but it is, an administrative proceeding in court. It is not meant to be a suit or a fight among contesting claimants or heirs. It's never meant to be that way. That is not the spirit of the Portuguese law. It is meant to be just a distribution, and every effort has to be made by judge, by lawyers, to keep the parties within limits so that they do what finally the law will settle everything, so there is no point in fighting. In inventory, basically what is done is the list of heirs and list of assets are furnished. You make a statement, you give the name of all the heirs, then you give a list of the assets. Then there is a valuation which has to be approved by the court. And based on this, The assets are distributed among heirs, taking into account the wills and the gifts. The wills, the gifts, the disposable quota, the legitime, everything is taken into consideration. It is pure arithmetic. It can be done very smoothly. If, already said it, a will or gift to anybody exceeds his rightful, lawful share, the same is scaled down by a process known as collation. Collation is a process within the inventory. And he or she has to compensate the other heirs for the excess by what is known as ovaltee money. In Portuguese, it is known as tornas. It's a famous word. It's a refund. Whatever, to the extent the gift made to you or the will made to you, that value exceeds your rightful share, that excess amount is distributed among the other heirs. You have to pay it. Otherwise, you don't get that asset. Now, an inventory without unnecessary objections and hassles can be completed in a few months. Not these days, because the courts are closed. But once this melody goes, this pandemic goes, when it was like before, a peaceful inventory, if all are agreed, in a few months can be completed, because the courts have a little time. Otherwise, it cannot be done within a month. It takes a few months because of the court dates. A smooth one. Now, if there are serious objections as to heirs, assets, etc., inquiry starts within the inventory. That inquiry takes time. You have to call a valuer, you have to call a witness to depose. The court has to decide, pass orders, and each inquiry becomes like a small suit within the inventory. That's why many inventories become like, people view them like as suits, or even a group of suits. They become very complex and very time consuming. But that is if there is a problem between the family members, as is often the case. Now, one point is that the marriage has to be registered in Goa under the Code of Civil Registration. This is important. When you say somebody is married to somebody, marriage certificate is required in all the succession proceedings and marriage proceedings also. Now, succession deed. Succession deed is a formal declaration before the notary public as to who are the heirs of the deceased, whether he has left any deed or gift, and what are the assets left by him. It was devised by the Portuguese government as a means to obviate the need to have a formal inventory. Now, succession deed is something which you do in the same office known as notary public. You have to take a group of declarants, 3 people, and who make a statement that this was the deceased person, these are his heirs, there are no other people. You have to submit the death certificates, birth certificates, and that document is as good as the court document to prove it's a proof of your heirship. It's a certificate of your heirship. There is also a mention of what are the assets that this is left behind. It is not actually a partition, but it already shows what is the estate and who are the claimants to it. If the estate exceeds a certain value, it has to be published in the Gazette. So it's open for objections by anybody. Now, this was done so that people don't have to rush to the court at the drop of the hat. So where all are majors, you can still make use of the succession deed. With the succession deed, you can get your money from banks, from institutions, or from whoever is holding the money of the deceased. Succession deed is sufficient for that. Now, if there is a minor, you can't do a succession deed. It has to be inventory. Inventory is compulsory when there is a minor, because when there is a minor, it is expected that the court will take charge and hold custody for the minor to protect the interests of the minor. So you can't do a succession deed. If all are majors, you can do a succession deed. Now, if all are majors, inventory is optional. You can do it, or you can also partition by what